And the XRP sits, as I said, on an open, permissionless ledger. How do I know that it's open and permissionless? Because the chief technology officer at Ripple tells me it is. He explains it to me, but I also have hard evidence. The SEC announced about a month or two ago that they're going to establish a node on the XRP ledger and other open and permissionless ledgers. The SEC didn't call Ripple to ask permission to do that. They're just going to do that. The SEC announced about a month or two ago that they're going to establish a node on the XRP ledger. They're going to establish a node on the XRP ledger.
Should take this off. Great. Thank you, everyone. We'll start this next fireside chat on cryptocurrency. This panel is called The Law and Regulation of Cryptocurrency. I'm pleased to introduce to you Stuart Alderoty, the General Counsel and Executive Vice President of Ripple, the Forbes Blockchain 50 provider of leading enterprise blockchain solutions for global payments. Thank you for sharing time with us and speaking to us about the law and regulation of cryptocurrency. Ripple connects banks, payment providers, and digital asset exchanges using its RippleNet blockchain. Alderoty oversees all legal, corporate governance, and insurance risk management matters. He previously served as General Counsel for HSBC North America Holdings. Prior to HSBC, Alderoty was managing counsel at American Express, and before that, a partner with the law firm of LaBeouf, Lamb, Green, and McRae. So, Stu, we've been talking a lot about technology's role in our economy and everyday lives. Let's turn to the newest area of technology, cryptocurrencies. I saw on my Twitter feed for several days that Ripple sent an open letter to Congress to say that the company is different from others in this space. Some of you might have read Stu's op-ed after the Facebook Libra hearings in the House and the Senate. And from my understanding, Ripple is different from Bitcoin, Ethereum, and Facebook's Libra. Ripple focuses on powering the technology of payment networks to improve on traditional banking services, such as the SWIFT network, interbank settlement, and wire services. So how should regulators and consumers think about Ripple? What's a pro-innovation regulatory framework for Ripple and other cryptocurrencies?
Well, thank you. Well, first, a disclaimer, I'm a lawyer. I'm not a computer scientist. I'm not a cryptographer. But Ripple, as described, is a company, it's a fintech company that embraces regulations because our customers are banks and payment providers throughout the world who are themselves regulatory. They're supervised by their regulatory agencies. So we have to comply not only with their regulations, but we have to comply with our own regulation here in the US. And globally. We're an international company. We have about 220 customers right now throughout the world, and that is fast growing.
Great. So a little bit more about your open letter to Congress and maybe about what Congress is doing around cryptocurrency. There's I guess, just low-level understanding of what it is, and there's good headlines and bad. Could you tell us a little bit more about XRP, the token, and the technology?
Sure. So, the reason that Ripple issued its Dear Congress letter was really in response to the Libra Facebook white paper. There was a concern that with the hearings in Congress, that those on the Hill were really leaning into the space, which was a very good thing. But there was also a concern that maybe that they would legislate in the breach. And to legislate innovation, I think you need to understand the differences in the innovation. And it was a letter to Congress that basically said, don't paint us all with the same broad brush. And there are those companies like Ripple, which is a software solution that we sell to banks, and those banks can or cannot use a digital asset to enable that software solution. That is not looking to displace fiat currency. We're looking to be a bridge between fiat currencies cross-border. We're not looking to topple central banks. We're looking to partner with central banks. And I think those are important distinctions in terms, despite what your impressions may or may not be of the Facebook Libra white paper. So it was really just a message to Congress that learn about the space, educate yourselves about the differences in the technology before you go ahead and legislate the technology.
And maybe you can tell us a little bit more. I believe Ripple is a few years ahead of Facebook in terms of getting all its regulatory paperwork done. If I'm correct, Ripple was one of the first 10 companies to get a broker's license in New York, or
a BIT license.
A BIT license,
right.
Yeah, from the New York State Department. Yeah. I don't know if Facebook's applied or received one.
Yeah. Well, Ripple is a money services business. We're not a money services transmitter. Our customers transmit the money. We provide the platform on which that they can do that. As a money service business, we're registered with FinCEN, which is the unit within Treasury that thinks about all things AML, BSA, and Know Your Customer. And then I think we were the second or third entity to get the BIT license in New York City. So we are regulated. We are audited and supervised by our regulators, but I think even more importantly, our customers are regulated by their supervisors throughout the world.
Wonderful. And what do you think, as kind of a bigger, more established cryptocurrency company or platform, about all the smaller players who might be not following all the compliance laws and rules?
Yeah. Well, I think I could approach that in a couple of ways. I think number one, I think you have to think about regulation and crypto globally. And there's a spectrum of global approaches. On one end of that spectrum, you have geographies which are pretty welcoming, both in word and deed, and I'll put Switzerland in sort of that bucket. And where they're basically saying, you can come to Switzerland. We want to create a crypto valley, because I think they missed out on Silicon Valley, so they want to create a crypto valley. And we're going to create a framework to supervise and regulate digital assets that's clear, that's principle-based, that's workable, and that will evolve as the innovation evolves. Then on the other end of the spectrum, you have geographies which are outright hostile. They haven't banned cryptocurrencies, but they've come close to banning cryptocurrencies, and in that bucket, I would put a geography like India. And then you've got in the middle a wide expanse of companies that are trying to figure it out, and the US is in that expanse of countries who are trying to figure it out. And I'll answer your question in a moment. And the way the US is trying to figure out is we have a multitude of regulators that touch it, which is not unusual, because in the US we have a multitude of regulators that supervise anything that connects to financial services. In 2015, the Commodity Futures Trading Commission, the CFTC, said that crypto assets are commodities. Chairman Tarbert, who was recently confirmed a couple of months ago, he said these are 21st commodities that are part of our yet-to-be-written future, and they have transformational promise. The DOJ has often treated these as virtual currencies. The IRS treats them and taxes them as property. We've talked about Congress. There are a number of legislative initiatives and bills that are being written in Congress to see whether or not there's a legislative answer to some of this uncertainty. And then you have the SEC. And the SEC has sort of taken a pronounced role. And the reason they've taken a pronounced role is because about a year or so ago, we had this thing called the ICO, an initial coin offering, that in hindsight was really riddled with fraud. It was really the sale of tokens, in many cases masquerading as the sale of a security. And a security is when I sell you something and I give you a right, title, or interest in my company. So I think the SEC did a really good job of quashing that fraud through enforcement actions. So they showed us what bad looks like. But now I think the SEC has gotten a little stuck because they haven't been able to show the industry what good looks like. They came out with a digital asset framework earlier in the year, which is about 14 pages. Depending on how you count, it has 30 factors. I've heard as many as 60 factors. But it's not really a workable or usable framework. One of their own commissioners has described it as a Jackson Pollock approach, where you just throw a bunch of paint, or in this case, a bunch of factors on a white canvas, and we all stare at it, and I say, what do you see, Sarah? And you see something, and I see something different. An industry can't be built around that. They also came out with a couple of no action letters. A no action letter is if I have an idea for a use of a token, I go to the SEC, I say, here's my representations to you. If I'm true to those representations, can you put in writing that you will take no action against me? The two no action letters that they've come out with are around tokens which were so obviously not securities that it actually created additional angst in the industry, because it's the equivalent of taking a Starbucks gift card to the SEC and saying, give me a no action letter that you will declare that my Starbucks gift card is not a security. So why do I give that long monologue? I give that long monologue is because I think the smaller companies that don't have the wherewithal of Ripple to hire fancy lawyers, when they're trying to weigh into this space and they're trying to innovate, and that's ultimately what they're trying to do at the end of the day, they're trying to innovate, they're trying to create, they don't have the wherewithal, they're going to flee to countries that are more welcoming and more tolerant of the innovation and of the creativity. And by way of contrast, I'll just point to the FCA, the Financial Conduct Authority in the UK, which just on July 31st, about 2.5 weeks ago, came out with their own guidance. And if you compare that guidance to the SEC's guidance, you can actually read it, you can understand it, you can work with it, I think you could comply with it. And the UK also says we're going to continue to evolve the guidance as the industry and the innovation evolves along with it. And what the UK said was that we're going to put these tokens into 3 buckets. A security token, a utility token, and an exchange token. And if you're a security token, again, if I sell you a token and I give you a right, title, or interest to my company, you're going to be treated and supervised and regulated as a security. If not, you're going to be treated as a utility token or an exchange token, or in some cases a hybrid of both. XRP was put in the bucket of being a hybrid utility and exchange token. Then they didn't get distracted by things like, is there secondary trading in the token? And both of the no action letters that the SEC issued both specifically said that there can be no secondary trading in the token. Secondary trading is an indicator of speculation. It's not necessarily an indicator of investment. The FCA, the Financial Conduct Authority in the UK, quite wisely said that people speculate in a lot of things. They speculate in wine, they speculate in cars, they speculate in real estate, they speculate in fiat currency, but speculation doesn't equate with investment. So again, while perhaps not as welcoming as Switzerland, I don't think the UK is saying we want to create a crypto valley in the UK, but they recognize that they're dealing with innovation, and they recognize that they're dealing with creativity, and regulation should not be the enemy of innovation. In the US, I think unless we get some additional clarity relatively soon, we're going to slide into a situation where regulation is going to be contra to innovation, and then the innovation is going to flee the U.S.
Great. So given the SEC's guidance, and I guess on the Howey test, how they would interpret an investment coin, do you think it'll be another 5 years of litigation to work out the facts? Will it be a case-by-case analysis?
Well, I think it would be a shame if we wait for 5 years of litigation to sort out this issue, because the issue ultimately will probably be resolved in the Supreme Court if it needs to be. But I think it would be a shame if that's where we end up. The SEC guidance is not law, it's not rule, it's not regulation, it hasn't been vetted by the Commission, and it's not binding. That's not my words, that's footnote 1 to the guidance. The guidance was meant to be helpful, but as I indicated earlier, I think it's had the opposite effect. I think it's actually expanded, if not distorted, the common law that's existed for 75 years, the Howey test, that we can talk about a little bit if you want. It would be a shame if we've got judges throughout the United States, New York, California, who knows where else litigation may ensue, deciding this question, because you may not get a consistent answer, and then ultimately have to work its way through the courts, I think ultimately to the Supreme Court to get an answer. And I think that would be unfortunate, because again, innovation is fast, it's impatient, and it's imperfect, and it's not going to wait 3 to 5 years for the courts to give us an answer.
And I guess another question is, well, what do you think about federalism? So many state legislators are coming up with their own bills to define token, to maybe provide more certainty than the SEC. What would you say to those state legislators? The laboratory of democracy, as Phil Weiser talked about last night.
Yeah. So, I think with the states, again, I will applaud any state who's trying to lean into the space and trying to be a thought leader, but I think if they're doing so because they see a gap at the federal level. New York, I think with its BIT license, provided a framework early on that companies like Ripple have embraced. Other companies have not embraced it, but there are a number of companies who have embraced it. Wyoming, I think, is leaning in. I think California is a state that should be leaning in. But I don't think we want to end up with a 50-state patchwork of different licensing regimes. I don't think that would be a good thing. I think it would be a very complicated and difficult 50-state patchwork to navigate through. I'm not saying it's impossible, but there's this void. And I think states are trying to fill the void. And I think at the federal level, that's where the void should be filled.
I could be wrong, but it's my understanding that a lot of companies are going to the SEC and CFTC for consultation of their business models. I don't know if that's true or not, but is there enough expertise for how to give guidance at the regulator?
Well, I think in all fairness, I think the CFTC and the SEC and the OCC and the CAPP, all of these agencies have either a FinHub or something akin to a sandbox where you can come in, you can have conversations, you can talk about what it is you're doing, which is great. I think they are welcoming. But unless we start to get some indication of what good looks like in this country as a result of those conversations, I think that turns out to be counterproductive. And as I said earlier, we've gotten a lot of indications of what bad looks like. We haven't had any indication of what good looks like, despite what I imagine are an awful lot of conversations going on with a lot of federal agencies and congressmen and congresswomen in the United States.
Great. And I guess so for my last question, I just wanted to find out a little bit more, and maybe the audience doesn't know, about just the banking payment networks and how Ripple speeds up payments. So there is like a news headline that Ripple is partnering with MoneyGram and providing faster ways of settling cross-border payments, if I'm correct. Yeah. So if you could just talk about Ripple's role in the banking industry and And that's different from consumer. So a lot of these fears are consumer protection and fraud. But for Ripple, you're working in a very traditional financial services space. So if you would describe a little bit about what is RippleNet and what are the use cases of XRP?
Sure. So two different things, what Ripple is and what XRP and the XRP ledger is. So let me start with Ripple. So again, Ripple is it's a software solution built on a blockchain that we sell to regulated financial institutions throughout the world so they can send money cross-border and convert that money into different currencies faster, cheaper, and more transparently in contrast to anything that exists today. And really what exists today is the SWIFT network, which is plumbing that exists on a 50-year-old plus framework. I think Ripple has created a software solution which allows banks to talk to each other and trust each other and message each other in a way that previously didn't exist. XRP, which is not owned by Ripple. XRP is not Ripple. Ripple is not XRP. If you own a unit of XRP, it gives you no right, title, or interest to Ripple. If you want to own Ripple, go into the secondary market and you can buy some shares in Ripple and become an investor in Ripple. But what XRP does, and this is really what I think is fascinating, because when you combine XRP with RippleNet, the proprietary software solution, I think it does something really magical. It's really the secret sauce. It's liquidity on demand. So the way that banks need to transfer money throughout the world now, as many of you know, is they need to pre-populate and pre-fund correspondent banking accounts throughout the world with millions, billions, and in fact trillions of dollars in anticipation of cross-border transactions that they think may, or they're predicting that may take place. Those correspondent banks charge a fee for that, and also the banks are beholden on FX brokers to execute FX trades when those cross-border payments take place. The trillions of dollars, and I think there's 10 trillion of dollars that sits in these correspondent banks, that's dead capital to the banks. And when I say dead capital, they can't use it to invest in their company. They can't use it to pay dividends to their shareholders. They can't use it to pay their employees. They can't even use it for a liquidity or stress test buffer under Basel III. It's dead capital. What the XRP solution in combination with RippleNet allows these banks to do is take the pre-funded dollars out of these correspondent accounts, put it back on their balance sheet, and now if I'm sitting in the US and I'm MoneyGram and I want to send $1,000 to you and you're in Mexico and I want to convert that to pesos, using RippleNet, you go into the marketplace and you go to a crypto exchange or a crypto market maker and you buy $1,000 worth of XRP. You send that XRP to Mexico. The market maker or the exchange in Mexico then converts it to pesos and then delivers it to the ultimate consumer. That transaction takes 3 to 5 seconds, whereas under traditional SWIFT network, that would take 3 to 5 days. MoneyGram, in their recent quarterly conference call, which took place 3 or 4 weeks ago, their CEO says on that conference call that this is as close to instantaneous transfer of money humanly possible that he has ever seen, which was a pretty powerful quote. Treasurers, if you're a treasurer of a bank, you love this solution because you control your balance sheet, you control the time of day that you want to execute the trade, and you control the cost of the trade because you can delay the trade until you get the price that you want to execute the trade.
Great, thank you so much. So we have some time for 1 or 2 questions from the audience, if any. Laura, yeah, and Greg.
Hi, I know this is an adjacency, but I'm interested in your opinion is when Facebook introduces Libra into the marketplace and there's huge backlash coming out of DC because of the regulatory scrutiny on Facebook and privacy in its core business, does that actually affect you or any of the stuff going on in your world negatively?
So it's a good question, and I think it goes back to the Dear Congress letter. And in the audience, we have Michelle Bond, our global head of government affairs. It affects us this way. Again, I think those in Washington don't understand the technology because it's a very complicated technology. And I think the danger is that we all get painted with the same broad brush. So my understanding of the Libra white paper, and this is a lawyer's reading of the white paper, as I said, I'm not a computer scientist, I'm not a cryptographer, but my understanding of the Libra white paper is they're seeking to create a currency to compete with other fiat currencies where central banks will no longer play a role on a closed and permissioned system. That's very different than using, what Ripple does is using an open, permissionless ledger like the XRP ledger to affect cross-border trades using a bridge currency. So Ripple's not looking to replace fiat. We're not looking to compete with fiat. We're not looking to compete with central banks. And the XRP sits, as I said, on an open, permissionless ledger. How do I know that it's open and permissionless? Because the chief technology officer at Ripple tells me it is. He explains it to me, but I also have hard evidence. The SEC announced about a month or two ago that they're going to establish a node on the XRP ledger and other open and permissionless ledgers. The SEC didn't call Ripple to ask permission to do that. They're just going to do that. So I think it affects us in this way, that we need to educate policymakers about what innovators like Ripple are doing and others who are building on the XRP ledgers and others outside of the Ripple network, what we're doing and how it's different than what Libra and Facebook appear to want to be doing. That's how it affects us. Because if those differences are not understood, we will be painted with the same broad brush. And I think that's a very dangerous thing in terms of the promise of this innovation.
Thanks. I'm Greg Roston. I'm at Stanford. And this was a great explanation of the difference between, at least I think now, between Ripple Net and XRP. I heard Chris Larson about 3 years ago explain how this worked.
I defer to Chris. If he explained it better than me, we'll take him.
No, he just was at a higher level that Ripple was going to facilitate bank-to-bank transactions. And what you described to me seems like two very different pieces, the network and the currency that moves over the network. And so from what I was listening, it was like you could have said there's the Ripple net and you send a Bitcoin over it, and it gets transferred on either end. But my understanding is that it's so fast that the fluctuations that would occur with Bitcoin are less with XRP. And so why not send something called a dollar over? Because it's just a notional thing anyway, electronic. My bank account has dollars in it, but I don't really have the pieces of paper. Why can't you send dollars over RippleNet? And I think there are TransferWise and other people are trying to do similar things. I think it's great to get rid of the all these exchange banks and that sort of thing, but is there a reason why you have to have a cryptocurrency go over this as opposed to something else?
Yeah, I think it's a good question. I think there are a few questions buried in there. So first, just to go back to the first thing that you said, Greg, was that RippleNet is a software solution that doesn't leverage a digital asset. It's basically a messaging platform that allows for interoperability between different banks. Different banks can decide which banks they want to trust. So we'll put that aside. XRP is specifically designed for speed to execute cross-border transactions. If you wanted to do what has been what I've described and what you've heard Chris describe with Bitcoin, you're going to have to wait for some miner to solve a mathematical riddle, which is using an awful lot of energy. All of the energy of Ireland, is devoted every year to solve these mathematical riddles. And you can't do that in 3 to 5 seconds. It'll take about an hour to solve that mathematical riddle to make that transaction work. The reason you won't want to use dollars is because what Ripple is solving for is cross-border payments, where a dollar is converted into a peso, and that's done in 3 to 5 seconds, and then I can decide as a treasurer of a bank when I want to execute that trade. In other words, I can keep pinging the system, messaging the system, until I get the quote that I like, and I say, that's the quote I want. That's the quote I like. If I send $1 out into the system and it hops between a number, probably at least 2 correspondent banks, and I'm beholden to a bunch of FX traders to make the trade, I don't know. I know ultimately that dollar will be converted to a peso at the end of the transaction, but I cannot tell you when that transaction will complete. I don't know if it'll happen in 1 day, 2 days, 3 days, 4 days, or 5 days, and I won't know the cost of that transaction until the transaction is completed. With this solution, you know exactly what it's going to cost before you hit the OK button, and you know exactly how long it's going to take, which is going to be counted in a matter of seconds, not days.
Great. Any last questions? Okay, one more.
Hi, Chris Martin with Access Partnership. You mentioned the lack of guidance here in the U.S. at the federal level and how we're seeing the states go in different directions. And to your point about different poles of openness to digital currency and you know, countries like India versus Switzerland, at the global level, is there any organizations that are involved in developing this type of guidance? So is Basel Committee coming out with stuff? Are there other institutions that are leading the way to show what is best practice at a global level that regulators around the world can draw on?
I think at a global level, the regulators in the first instance are most concerned with anti-money laundering regulations, which I think is a good thing. Because cryptocurrency shouldn't be used to skirt anti-money laundering regulations. So they're trying to come out, they're not trying, I think they have come out with some global guidance. But I think beyond that, although other G7 or G20 or the BIS have gotten together and they've talked about this, quite frankly, the world of cryptocurrency is simply not big enough yet. It's not even approaching anything that would be a systemic risk. So I think while there's been a call for some international cooperation, and I think there's been some discussions about international cooperation, I think if you read the papers of some of the international regulatory bodies, what they're basically saying is, let's watch this space, because it's simply not big enough yet for us to be that concerned about. That having been said, I think there are some, and again, there's been a commissioner on the SEC who has said we can learn from other jurisdictions, whether it's Switzerland, whether it's Japan, whether it's Hong Kong, whether it's the UK. I mean, these are very, very well-respected economic centers with very mature and sophisticated regulatory structures. So I think there's a lot that we can learn from, but I have not yet seen a call for international sort of cooperation yet.
Great. Thank you, Stu. Let's give
thank
him
you.
a round of applause. Thank you.